All right, well, thanks for having me here, and thanks for the invitation. I'm Zach Wolf. I'm a lawyer with the firm Fleckman and McGlynn, which has offices in Austin and here in the Houston area. And I was asked to talk about issues that might be of interest to pathway forensics. So I came up with the title, Dude, Where's My USB Drive? Forensic Issues in Departing Employee Litigation. So first of all, departing employee litigation, what is that? Usually if I meet people and I say I'm a lawyer and they say, what kind of law do you do? I don't say departing employee litigation because most people would be like, what does that mean? You know, like, is that employee discrimination or something? No. So what I say usually is I do non-compete and trade secret litigation. And usually people kind of have a sense of what that means. Most people know what non-competes are and they kind of understand what a non-compete lawsuit would be about. So that's really where my practice is focused. I do other kinds of business litigation too, so it's not just that, but that's sort of where I've made a name for myself, and I write a lot of material. So on my blog, 5 Minute Law, I've got a lot of stuff about departing employee cases. I've got a YouTube channel called That Non-Compete Lawyer, and there's a lot of stuff there as well about, of course, non-competes, but also trade secrets. So this assignment was a little daunting because I thought, what can I really teach forensic experts about forensics? Probably not much. So that's not what I'm going to try to do. What I want to try to do is give y'all a sense of what the lawyers are looking at in the cases where you get hired, in particular in these departing employee scenarios, which I'm guessing are pretty common in your practice area. How many of you have worked on some kind of scenario involving departing employees? Yeah, probably everybody in some way. Yeah. So what's I want to give you a sense of what are the legal issues that the lawyers are looking at, what are the strategic issues that the lawyers are looking at, so you've got a better sense of how you fit into that, and hopefully so you can provide better service when you get hired by law firms or lawyers to help them in these cases. All right, so let's start with a typical scenario. My title references a USB drive. How many times have you seen a scenario like this? Let's say a top salesperson at a company suddenly gives a resignation and leaves the next day. And then the company a week later discovers the salesperson is working for one of their competitors, one of their fiercest competitors, right? And they're freaking out. So they do their own little internal investigation and they look at the employee's laptop that the employee turned in. And what do they find? It looks like a USB drive was plugged in the day before the employee left. Shocking, I know, right? But this does happen. And they find that a huge amount of company data was transferred to this USB drive. And so they're concerned. And so then they go and hire a forensic expert. So that's the basic scenario. And then let's say, company files suit. Come on in. Company files suit, sues their former employee, maybe also sues the competitor that hired the employee, and they go to court. Maybe they ask for a temporary restraining order, and then a temporary injunction after that. And a lot of times what they want in the TRO or in the temporary injunction is the judge to order the employee to turn over the information that was taken, maybe to turn over the computer or smartphone or other device that has the information, and they probably are going to have a forensic expert involved in that process. So that's the basic scenario. So I thought of 3 big topics that I could touch on that come into play in that scenario. So the first is, what are the legal duties that the employee has to the company? The second is, how does the employee return company files to the company? Almost every employee is going to have something that belongs to the company, and usually there's going to be some employment agreement or company handbook or something that says when you quit, you have to return all company property and company files. Now that's pretty simple when we're talking about paper, but if it's an electronic file, how do you return an electronic file? So that's a big issue as well. The third issue is the subject of the blog post that I circulated, so y'all have a copy of that. It's the question of direct access. In civil cases, as you probably know, most of the time when there's a request for production of documents, each side gets to do their own searching and production, right? If I'm serving a request for production on the other side, I don't get to go through their office and look through their file cabinets. They do that. The same thing applies when the information is on a computer. And today, of course, most of the discoverable information is going to be on a computer. When, if ever, are you allowed to get direct access where either the attorney or an expert hired by the attorney gets to actually take possession of the other side's device to do some kind of examination? By the way, have any of you been involved in a direct access situation? I'm sure some of you, yeah. So it does happen. Okay, so those are my three big issues. We can take them in any order y'all want. So what sounds most interesting? Anybody want? Somebody pick an issue and we'll start with it. Cloud.
Dropbox, OneDrive.
Dropbox.
That's
yeah.
hard to return.
The return. Yeah. Okay. Let's start with that. Great. Yeah. Great point about cloud and Dropbox. A lot of times that's where the employee has put the information. Okay. So I'm going to make some notes about returning company files. So here's the decision tree for the lawyer who represents the employee. I get hired on both sides of these things, but so sometimes the company, sometimes the employee, sometimes the second company that hired the employee. And what will happen is that usually there's going to be something in the employee's contract that says they have an obligation to return company files when they leave. And so then usually there's going to be some kind of demand that the employee return the company files. So the question is, what do you do in that situation if you're the lawyer responding to that request? And so there's basically three options. So option one, I'm going to call physically deliver and delete. The second option, I'm going to call forensic image and produce. And the third option, I'm going to call produce and keep. All right, let me walk through these and explain the considerations that the lawyer has in deciding what to do. And of course, there are variations on all of these. So first of all, physically deliver and delete. Let's say the employee has a laptop. It has some company information on it. I could put it on a USB drive, deliver that to the other side, and then tell the employee, okay, now delete all of that that's on your laptop. Okay. Does anybody see any problem with that approach? Yeah.
We don't trust their delete. We secure delete, so usually we have to be the ones to remediate. Delete's not delete, or else we wouldn't be doing forensics if delete was delete. So therefore, that's not good enough.
Yeah, great point. So the point, I'll reformulate it as it's a trust issue for the company. How do I know you've deleted that? And even if you've deleted it, of course, as y'all know, delete doesn't really mean delete. And even most lay people are starting to understand that. So that's one problem. Another problem is that there's also a duty to preserve evidence, right? And the issues in the lawsuit could be about when did you put it on that computer? When did you delete it? You know, what folders was it in? Did you email it? And if you start deleting stuff, you're screwing up the evidence that could be relevant in the lawsuit. Now, you could say, well, if the company demanded that I delete it, and I deleted it, they can't really complain later, right? I mean, you could take that approach, but I think it would make me nervous. I don't want my client deleting stuff unless there's like a very clear agreement with the other side. We're going to delete, and here's how you're going to verify we deleted. So, so the duty, you've got sort of two potentially conflicting duties. You've got the contractual duty to return the files. You've got a common law duty to preserve evidence. One other consideration with this is a more sort of self-interested consideration for the employee and the employees counsel, and that is a lot of times the employee has some potential claim against the former employer. Usually that's going to be some kind of claim to compensation that may still be owed. That's especially true when you're talking about salespeople who are often working on commission. So a lot of times, and I've had this situation multiple times where the employee is owed some kind of performance bonus or a commission that has not yet been paid, or the employee might still be some kind of equity owner in the company, and the employee has company documents that I might need as evidence to prove that claim. I'll give you one example. So I had a case where a client was an executive and he met this financial milestone to get paid a performance bonus. He left, and when he asked about the bonus, the company said, "Oh no, you didn't meet the milestone." Now he knew from internal documents that it looked to him like he had met the milestone. He held on to those documents. And in that situation, I made a judgment call. I did not have him delete the documents. We didn't return the documents. Eventually, we produced them in discovery, and the company's lawyer wasn't really very happy that he had held on to these documents. And the company's lawyer said to me on a phone call, "Zach, I got to tell you, my client's kind of upset that he kept all these documents." And I said, "Yeah, I understand that, but he needed these as evidence to prove his case for his bonus." And the lawyer said, "Well, he could have just turned them over and then asked for them later in discovery." And I was just thinking to myself, yeah, right. I mean, how do I know I'm going to get them in discovery? Or how many months am I going to have to fight in court to get them? So in that situation, I made that judgment call. Okay, but here's another option: forensic image and produce. And this is probably the safest option, and it's also the option where experts like y'all can help. And that option is to say, okay, I'm going to tell my client, all right, don't touch that device. We're going to get a forensic image, whether it's the smartphone or the computer or tablet or both. We're going to get an expert, get a forensic image made of everything right now, so we have our archive copy. I'll take possession of that. I've seen it done different ways. Sometimes the client takes possession, but if it's okay with the client, I'd rather take possession of that. Then the client keeps the devices, and if it's personal devices, then they can keep using them, and I've got my forensic image. And then I'm going to produce a mirror image copy of that to the company or the company's counsel. Now, the potential flaw in that is the company could take the position that I did not, or my client did not, strictly comply with what the contract says, right? Because I still have all that information. But if you're in a situation where there's litigation or you anticipate litigation, I feel like it's a pretty reasonable position later to be able to say in court, well, to the judge, we knew that litigation was coming, and I was involved as counsel. We took possession of this information. This was not for the purpose of using it against the company. It was only for the purpose of preserving it as evidence. I think in most cases, a judge is going to see that as a pretty reasonable position. So this is generally the position I would advise in most cases. But it's always going to be a little bit of a judgment call, because you have this tension between the contractual duty, the duty to preserve, and then also just your self-interest in wanting to preserve evidence to prove your own claim. Okay. But one problem with number 2 is that it's kind of expensive, right? I mean, it's not cheap to get a good forensic expert to do this. I mean, it has become fairly standardized, so it's not as expensive as it used to be, but still, client is going to incur some expense. And in a lot of departing employee cases, you know, sometimes I'll get brought in before there's any lawsuit, and a lot of times these things get worked out pretty quickly, and it never goes to a lawsuit, and, you know, there's no real need to go to the step of forensic imaging. If you got a case like that, I think it's probably pretty reasonable to just send the stuff, make copies yourself, the lawyer or the client, send it to the company, client keeps their devices, and if everybody's happy, then you don't worry about it. So that is an option in some cases. It's obviously, it's not as cautious as option number 2, but as a practical matter, that may be the best option in some situations. So questions about these 3 options and what's best? Any questions about that? No? Okay, well then, in that case, let's see, do we want to go to how to return, or that's what we're talking about. Do we want to go to employee legal duties, or do we want to talk about direct access next? I'll let y'all decide.
Direct access.
Direct access, all right. Let's talk direct access. That's a fun topic. There was a fairly recent Texas Supreme Court case about this, and it's about a year old now. So direct access, first we're going to talk about the Weekly Homes case. If any of y'all keep up at all with case law in the ESI area, you've probably heard of Weekly Homes. Important ESI case. The more recent Texas Supreme Court case that deals with direct access is a case called Shipman. So we're going to talk about that. And then let's talk about how those apply to the departing employee scenario. So we'll talk application. And number 4, we're going to talk about protocols for direct access. I'm sure y'all have dealt with that before. So, Weekly Homes was a discovery case that focused on deleted emails. And one important thing that Weekly Homes said was that when a lawyer is sending a request for production of documents, you're supposed to specifically ask for deleted emails if you want them. And a lot of lawyers probably don't realize this, and you get a lot of requests for production that are not going to specifically say deleted emails. Now, some lawyers are going to see that and say, okay, well, I'm changing my form. Every form is going to say, I want all deleted emails. Well, hold on. I mean, do you really need that? You need to think about what type of case is this? Is the expense of recovering deleted emails justified in this case? In a departing employee case, a lot of times the emails themselves and when they were received or deleted, that sort of thing, could be an issue. But in other kinds of cases, it might not be that important. So people shouldn't just take the knee-jerk approach of, okay, I'm going to ask for deleted emails every time. But if you want them, you're supposed to ask for them specifically. So that was one thing that the court said in Weekly Homes. The more important issue was was it proper for the trial court judge to order that the responding party had to produce their devices for direct access? And the court said no in the circumstances of that case. And the issue there that the court focused on was that the requesting party had not laid enough of a foundation to show that direct access was warranted. They did show, it did appear that the responding party had failed to fully comply with the request for production. You've probably seen cases like this. You know, there's a request for emails, responding party produces like 6 or 7 emails. And you're like, oh, come on. Really? I mean, there's only 6 or 7 emails. It was a situation kind of like that, just a handful of emails. And so the trial court judge, I think, was skeptical, you know, about whether they had really done their job. And, you know, could there be deleted emails that were not produced? That was the suspicion. But what the requesting party failed to do in that case was they did not offer evidence that their forensic expert would be able to recover deleted emails from the device. Now that case, I think that case is about 9 years old now, something like that. When I read that, I was getting ready for today, and I reread part of Weekly Homes, and I don't know about y'all, but I kind of felt like, wait a minute, isn't it just kind of common knowledge that a forensic expert can recover deleted emails, right? I mean, today, that seems almost obvious, right? But the court back then said, no, you needed some evidence. Now, the evidence could have been as simple as just an affidavit from one of you saying, I'm an expert on forensics, here are my qualifications. You know, if given direct access to this device, it is likely I will be able to recover deleted emails, you know, and here are some methods of doing it, right? And this is industry common knowledge, you know, something like that. That would have been enough. But the requesting party in Weekly Homes didn't do that. And you know, as a lawyer, I try never to blame the lawyers in a case when I read it like this, because I could have done the same thing. I might have just thought, well, that seems kind of obvious. Do I really need to submit an affidavit on that? So that was Weekly Homes. And it laid out a step-by-step framework for how you get direct access. This wasn't really an issue in the case, but another thing they said was you need to have some method of protecting private information and privileged information, right? Because I mean, that's one of the big concerns with direct access. There might be plenty of relevant evidence on there, but there could also be a bunch of irrelevant stuff that belongs to that person. It's their private information. And there could also be privileged information. There could be emails with their lawyer on that device. So you got to do something to protect against that risk, and that's where protocols come in. So I'll get to that. But before I do, I'll go to Shipman. So Shipman was last year. It was another direct access case, and again, the Texas Supreme Court said no. The trial court judge went too far in ordering direct access. But the reason there was different. The reason in Shipman, it wasn't a question of whether the expert would be able to recover data. It was a question of whether the responding party had defaulted on his discovery obligations. And they took that language straight out of Weekly Homes. And what that means is that you don't get direct access just in the ordinary discovery process. You've got to show that you asked for stuff and the responding party didn't provide it and didn't object to it, but they failed to do what they're required to do. And which includes, you've got to diligently search for responsive documents, right? You can't just do some cursory review and say, oh no, we don't have anything. You have to be diligent. So you got to show that responding party defaulted on their obligations. In the Shipman case, what happened was you had a guy who initially said, no, I don't have anything. Then he testifies in his deposition, And then after his deposition, he goes back and gets his son's help. It's always good to have younger people involved, right? He gets his son's help looking at his computer, and they find additional documents, and they produce them. So in that case, it was a case really of late compliance. But the party that had requested the documents, understandably, they're a little suspicious. They're thinking, well, wait a minute. First you said you had given us everything. Then you come back and say, oh, I found some more. How do we know that you've really done a diligent job of searching? We want our own guys. It gets back to your point about how can I just trust that you did it right? And it would be one thing if it was just a question of, do you have the ability to do it? You might have some mistrust there. But when you're in the adversarial process and people have an incentive not to find stuff that's going to hurt their case, that raises the level of distrust even more, right? So you can understand why the requesting party in Shipman wanted direct access. The problem was they didn't have enough evidence of a default in meeting the discovery obligations. And you see this phrase about how mere suspicion or mere skepticism is not enough. It's not enough just that you're skeptical about whether they've done a good job. You got to have some specific evidence that they failed to meet their discovery obligations. So what I did in this little blog post that you can read when you get a chance if you're interested in this direct access issue, I came up with sort of a hypothetical where and lawyers love to do this, right? Let's change the facts a little bit. How's it going to come out if I change the facts a little? So I changed the facts to where the responding party in her deposition was very evasive about what she had searched for, and would never even say whether she had searched her computer. Would that be enough to get a direct access order? Hard to say. On one side you could say, well, you haven't proven that she failed to do it. On the other side you could say, well, the evidence looks pretty fishy. That looks like a case where direct access would be warranted. So that's basically the Shipman case. All right, now applying that to the departing employee situation, I think that if you're trying to get the documents and you're suspicious, so let's say the employee has a laptop and you believe that company documents went on to her laptop, you want your own expert to be allowed to search that. I think what it comes down to is the lawyer is going to probably need to take that employee's deposition and really ask specific questions about how that person searched their device, to build a record that they haven't done it diligently enough. That, in most cases, that's probably going to be how you do it. If you don't have some evidence like that, you're going to have a hard time persuading the judge to order direct access. Now, it's a little different, I think, at the TRO stage if you've got evidence of employees really behaving badly. If you've got evidence of really sneaky, underhanded stuff, and you go to a judge for a TRO and it's on an emergency basis, I think there's a pretty good chance a lot of judges are still going to grant some kind of direct access. And in that case, in a TRO, there's no appeal from it. The remedy is just to go to a temporary injunction hearing. I'm talking in state court. It would be fairly similar in federal court. So that's kind of how I think these cases typically apply. And then you get to this issue of what's your protocol. So if you get a direct access order from the judge, it should probably provide for some kind of protocol for how that direct access is going to be done. Now, before I get to that, I'll point out that under weekly, one way where you can be helpful to attorneys you work with is on this weekly Holmes point of showing how the forensic examination would work and how it would yield results. right? Because the lawyer can't really provide that evidence just on their own. So that's an area where you can help out. Of course, you can also help out with protocols. And I'm guessing that y'all probably have form protocols that you work with. And sometimes these will be done by agreement. I've got a case right now where a client had some company files and there's no lawsuit, but I wanted to avoid, I'm trying to avoid a dispute, avoid a lawsuit. So we offered to do some kind of direct access, and so we agreed on a protocol with the expert, and we're going through that process right now. And in this particular one, it's a process where, this is probably pretty typical. It's a process where the expert gives us a file directory, so we see all the file names. Then my client had the opportunity to identify files that were private or not related to the company, and so then we identify those, we provide those to the other side. They have a chance, if they think that maybe it is company information, then they can raise that issue and we can try to work it out. Have y'all dealt with protocols like that before? Yeah, okay. The one thing I'll point out, I had a bad experience. It wasn't with this company, but I had a bad experience with a protocol where my client had been ordered to produce her device for direct access and imaging, and I came into the case in the middle, and I asked the expert for the file directory. I got that information, and I could tell from the information provided that the expert had turned over more information to the other side than they were supposed to. It may have been inadvertent, but I was like, wait a minute. She's got personal emails, personal text messages. This is looking like, it looks like you turned all this over. And so I had to object, and eventually that case settled. But I took away from that a little bit of skepticism about making sure that the expert is actually following the protocol. And that sounds pretty obvious, but my word of caution to you would be, as the expert, don't just look at the protocol as kind of just, it's just a bunch of boilerplate, who cares, I mean, take a close look at what it requires. And, and it kind of raises a little bit of an ethics issue too, because you may be working for counsel who are aggressively trying to get everything they can, and you might at some point have to say, no, I can't give you that. Take a look at the protocol, and they may be unhappy, but I think if you point out, sorry, I mean, the protocol says this, I'm an expert, I've got my reputation to maintain, I can't become known as somebody who just breaks protocols, right? And, in most cases, with most lawyers, they're probably going to appreciate you pointing out that something doesn't follow the protocol. They don't want to get in trouble with it either. So that's my word of advice on protocols. Any questions about any of these direct access issues? Or do you have a good story? Yeah.
Well, I guess the question on the direct access, when we're doing our analysis, we can turn up evidence that there are other devices. Mm-hmm. And sometimes, like if we're working for the producing party, not the requesting party, just as an example, if we uncover evidence that there is the existence of other devices that aren't specifically at issue or being requested by the requesting party, what obligations are we under to disclose that to the parties? I understand there's, to our client, yes, there are obligations, but if we know, for example, that I tell my client, hey, there's 2 other computers, I can see evidence that there's 2 other devices that our client has in his possession, are we obligated to disclose that to our client? But then I guess the larger question is, we can't disclose that to the opposing side, correct? Or is it, I'm just kind of curious about what, I'm sure there's a lot of ethics and stuff involved in there as well, but there's also some legal questions in there too. Like we can't just go in and start injecting and disclosing things without, coming afoul.
I just had that happen recently, so how would you suggest handling proof, introducing, I guess, when you've got opposing and plaintiff side
Yeah.
How do you
yeah.
introduce non-compliance if you discover a record of non-compliance to the original protocol?
Because we do see that, and there's always a struggle, like, well, what am I supposed to do here? I feel like, we obviously disclose information to our clients so that they're aware of it. Attorneys are under their license, and there's ethics there. They're supposed to do something with that information. So as far as I'm concerned, in that scenario that I just laid out, we're disclosing that to our client, and then what they do with that then is on them. And we're sort of limited because, I can't just call the opposing attorney and say, hey, guess what? My client's lying to you, there's all this stuff out there. But if I'm deposed, then that question's asked, at that point, obviously we're under oath, we have to answer the question.
But when we're assigned as neutral, see, that's the other,
Well,
like, sometimes as a
neutral's
neutral,
totally
you
different.
release it to both sides at once and start a war.
Yeah, those are great questions. So first issue, you're the expert. You, in the course of your examination, you see that there are other devices that could be relevant. That is certainly relevant to the case and information that
Let's
you want.
let's say it's after the discovery protocol. In other words, after the deadline to turn over devices, now we're seeing this non-compliance.
Okay, right, and so in addition to that, just in general, there could be evidence of non-compliance with the order or agreement, right? So, that's a tough one. I think the place to start is the order or protocol or agreement, whatever the governing document is. I'll take a close, hard look at that and see, obviously if there's something, and I would bet a lot of times the protocol is not going to be specific enough to cover this situation, which is why you're asking, right?
Yeah.
Because it may not say. But first look at what it says. If the protocol is very narrow and says, expert, here's what you're going to do. You're going to provide a report that says X, Y, Z. And if that's all that you're authorized to do, then under a very narrow order like that, you might just need to just sit quietly, and if it comes up later, you would say, that wasn't part of my mandate in this order. On the other hand, I bet that most orders are not going to be quite that narrow. So if there's nothing in the order or the protocol that prohibits you from disclosing, it's a judgment call, but I would kind of lean towards disclosing. Generally, transparency is better, right? Getting more information. Now, I think I would, especially now if you're engaged as a neutral expert, then I think pretty obviously you disclose to both sides simultaneously, whatever it is you're going to disclose.
Right.
And maybe one way to sort of soften the blow is when you disclose it, you don't have to disclose it with any commentary or anything.
Yeah.
It could just be as simple as, here's what we found, and there's evidence of connections to these devices, period.
Yeah.
Not saying, so we're questioning compliance, or, the lawyers will see that and probably jump on it.
I've done that
Right.
before, where it's in the report that I was requested to produce as part of the neutral engagement,
Yeah,
that there's evidence that, this webmail account was used to send the stuff. Well, somebody, as long as they're reading it, can put two and two together and look at the evidence and go, wait a second, that's not something we've collected, that needs to get collected. And so it sort of works itself out.
Right.
So it's sort of, there's ways to disclose that where we're not just, blowing a whistle and,
Right.
put it out there, so still stay within the bounds of the agreements, but
right.
anyway.
What's the typical software that y'all would use for, I know there's different ones, but for, let's say you're doing a basic forensic image and you're going to provide a directory of that. What's something you would typically?
In case.
Yeah, in case, that's the one I know the best. Would the reports generated by in case usually just sort of routinely show that information? No, so it's something you would have to sort of add
just the
yourself.
analysis.
Yeah. So that does make it more complicated.
Yeah.
It'd be simple if you just say, oh, "Here's the report from in case," and then they're like, "Oh, wait, what's
Wait a
this
second,
device?"
Yeah.
But so that is a tough
And
one.
of course, that feeds back to protocol, so obviously, if the protocol has already specified what we're analyzing, then we have to take in consideration is what a lot of times, just being what we are, expert-wise, I can see it, I can spot it.
Right.
You give me the image, boom, okay,
Yeah.
there it is. But if that's not in the protocol, then it comes to am I even supposed to disclose?
Right, right. Well, and another thing that brings up is that another way you can help the counsel who engages you is up front with the protocol, raising this issue and saying, hey, what are we gonna do? You know, just a lot of times we see stuff and it may not be in the protocol, so you might wanna adjust your protocol so that, you know, I'm allowed to disclose whatever I see.
Mm-hmm.
And that would be a good thing to add, especially if your client is the party who's trying to get the information.
Yeah.
You know, the requesting party.
Yeah.
Yeah, but those are great questions.
Yeah, most of the time, you know, our clients will take the information that we give them and say, we see these other devices and disclose that. They're ethical attorneys, but
Right.
every once in a while, we work with some that are like, well, unless they raise it, we're not gonna say anything about it.
Yeah,
And, look, I've told you what I know.
right.
What you do with it's up to you, but, you know.
Yeah, and that may be, in some cases, that may be a reasonable position for them to take if the order,
Right,
you know, from the judge or the agreement doesn't provide for
Yeah.
that.
yeah.
Yeah. Good questions. So that's direct access. How often are y'all seeing direct access?
Quite often.
Quite often.
Mhm.
Is it, would you say more often where it's pursuant to a court order, or is it more often just by the attorneys agreeing? I imagine it's a split.
It's a balance.
Yeah.
Mostly protocols,
Yeah.
stuff by attorney.
Right, right. Yeah, because most attorneys know if it goes to the judge is probably going to approve some kind of protocol that's reasonable for that. So that makes sense. Other questions on direct access? Yeah.
How would you handle, and it's sort of the flip of the coin, not fine, how would you handle spoliation claims, obviously? So, you know, protocols are agreed upon, and then the only thing we can produce and find is that it's all gone. It's all wiped out, deleted, whatever, after an order to produce. How do you handle spoliation claims or anything like that?
Yeah, I think it really gets back to what's the scope of your assignment. And if the scope of your assignment includes identifying evidence of deletions, things that are destroyed, then yeah, you want to disclose that, and then that may lead to a second step of
Sanctions, maybe,
I'm sorry,
like sanctions.
could lead to sanctions, or maybe there additional forensic examination, or maybe additional devices. But yeah, and that's also where you may find yourself testifying.
Yeah.
Right? So whether it's by affidavit or live, in a deposition or in the courtroom. So be prepared for that. How many of y'all have testified on a forensic issue? A couple of y'all, yeah. So a bunch of you have. So, and how many of those who have had to testify, has that been deposition, courtroom?
Yes.
Some
yes.
some of
All
both,
of the above.
all of the above. Okay,
Yeah.
yeah. I'm curious, how many of the opposing lawyers questioning you, how would you rate their knowledge of forensic issues?
It's all over the chart.
All over, yeah.
Some
yeah.
of them are very, obviously, they have, the better ones are the ones that have an expert that's feeding them questions,
Right.
or that this is, they take all the cases that are dealing with these issues on a regular basis, and so they're very familiar with the protocols and the process and tools and their capabilities.
Yeah.
Where they're the worst ones, there's when, they don't know the tools, they don't know the capabilities, they don't really know how to use an expert, and it's painfully obvious that they don't, when they're asking questions, and, they just kind of skim the surface, so.
Right. Right, yeah, it can be very painful sitting through a deposition of a forensic expert, or really any kind of expert, when the attorney has no clue about the area of expertise, right? And you don't even really speak the same language. Yeah, I think it's getting better. I mean, obviously, most lawyers are getting at least some basic knowledge of forensic issues. I mean, it's hard to avoid now if you're a litigator, but you still find some who are still a little clueless about it. All right, well, let me see how much time. we got a little time left. I'm gonna do a 10-minute law school course for y'all in employee confidentiality duties. So we won't go into great detail, but hopefully this will help you a little bit in understanding kind of how your work fits in to the lawsuit. So these are the big employee legal duties that are usually at issue in a departing employee case. Trade secrets, that's pretty obvious. A lot of times that's an issue. I've already mentioned confidentiality agreements. So that's number 2. Number 3 is, and by the way, trade secrets is statutory. There's trade secret statutes that govern that now. Confidentiality agreements is really a common law issue of just applying contract law. The third one is also a common law issue, which is fiduciary duty. And employees under Texas law have a sort of limited fiduciary duty. I call it fiduciary duty light because it's not really a full fiduciary duty, and I'll get to that. And finally, this one may be of most interest to you. There are anti-hacking statutes. Both federal and Texas has one. So now there are other legal duties. Yeah.
So, just a quick,
yeah, go ahead.
Out of those, obviously probably number 1 or 2, where does non-compete fall into?
Non-competes, I would put that's a great question. I could have included that.
Kind of like a confidentiality
related to confidentiality agreements because it's contractual.
Okay.
Yeah, and the big thing with non-competes that makes it a little different from confidentiality agreements is that, as you probably know, there are limits on non-competes. You can't just agree on whatever you want, right? There are reasonableness limits on non-competes.
And time.
Right. Now, I did these because all of these deal with confidential information in some way. Non-competes go beyond that because they are dealing with not only confidential information, but goodwill,
yes.
Right? Which is fundamentally different really from confidential information, even though there's some overlap there. Yeah, that's a good question. So I'm just going to hit each one of these and just give you a couple key things to keep in mind so that you kind of speak in the same language when you talk to lawyers about this. Trade secrets. What makes something a trade secret? I'll give you 2 points to keep in mind. One is the phrase competitive advantage. Now it's interesting because trade secrets in Texas used to be a common law issue, meaning it was established by court decision, not by statute. And the court decisions used this phrase competitive advantage. And a good example that illustrates that is, let's say my employer has my healthcare information. Maybe they have information about what prescriptions I'm on, how many times I've seen the doctor or something like that. That's confidential information, right? That's not a trade secret, right? That information doesn't give them any competitive advantage over another law firm, right? So not all confidential information is a trade secret. The issue is, think of it this way, would it give somebody else a competitive advantage to know that information? That's the basic concept. More specifically, the big fight usually when you're talking about trade secrets is over the concept of, is the information readily ascertainable? You may have heard that phrase before. Yeah. Obviously, if the information is public, it's not a trade secret. But what if the information, it's not exactly public, but a competitor could easily go and compile that same information? A great example of this is a customer list. And is that a trade secret? Well, it depends. That is a fact-intensive issue, and it comes down to whether it's readily ascertainable. One kind of case I've dealt with where customer lists are important is financial advisors. So think about this. If I have a list of a company's clients, and they're all really high net worth people, and I know what their net worth is, and I know what they're invested in. That's probably not readily ascertainable, right? I'm going to have a hard time. I'm not going to just be able to Google like rich people who want to invest and pop up a list. No, it doesn't work like that, right? So usually, and these financial advisory firms, they guard those customer lists very jealously, and they certainly consider them trade secrets. On the other end of the spectrum, I had a case involving the wholesale lumber industry, and my clients had lists of their customers, and it was almost comical because, for example, companies that sell wooden pallets buy lumber, right? Is that readily ascertainable? I think so. Are the names of pallet companies readily ascertainable? If you Google pallet companies Houston, and you'll get a list that looks pretty similar to the customer list in that case. So that was a good example where there was a strong case that it was readily ascertainable. Where it gets difficult is the gray area in between, right? How readily is readily? Like if I could reproduce it, but it would take me a month to do it, that's probably not readily ascertainable, but you get cases in the middle. So that's trade secrets. Confidentiality agreements. The main point here is you probably have seen confidentiality agreements where it defines everything and the kitchen sink as confidential information. That's kind of the problem with the way these agreements are written. I don't write mine that way, but a lot of times they're written like that. So just keep in mind, just because the agreement says it's confidential doesn't necessarily make it confidential. That raises the difficult legal question of what if somebody discloses information that the agreement defines as confidential, but it's not really confidential. Have they breached the agreement? I don't have a good yes or no answer for you. That's a tough one.
It's tough because intellectual property gets widely, the definition of intellectual property gets widely interpreted.
That's right, yeah, and often these...
Company logo on the top of the page doesn't make it intellectual property.
Right. That's a good point. And with intellectual property, some kinds of intellectual property are confidential and some are not. This is where ordinary people get confused a lot, like patents. A patent is not a trade secret. It's not confidential. A patent is disclosed to the public, right? So, and same with a trademark. The whole point of a trademark is that the public associates the trademark with a certain company, so that's not confidential. Yeah, so be careful about when people can want to sometimes confuse intellectual property versus confidential information. All right, third one, fiduciary duty light. So I said that employees have a sort of fiduciary duty. What do I mean by that? Well, as a lawyer, I have a fiduciary duty to my client, which is the highest duty the law recognizes. And the key thing that makes that duty different is that I have a duty to put my client's interests ahead of my own. There's really no other legal duty that has that feature, and that's pretty onerous. An employee doesn't quite have that level of duty, right? Because as an employee, and I'm talking at-will employees mainly, I can go look for another job. I don't have to tell my employer I'm looking for another job. I can even go and look for a job with a competitor, putting aside non-competes for a second. And I don't have to tell the employer. And Texas courts have said that's not a breach of the employee's fiduciary duty. What is a breach is taking the company's confidential information and using it in competition with the company. That is a breach of the employee's common law fiduciary duty light. An important point about that is number 3 applies even if there's no confidentiality agreement. So it's good for companies to have these confidentiality agreements, but even if they don't, the employee still is not allowed to use the company's confidential information, and take it with them and go to a competitor and disclose that information to a competitor. That is a violation of this duty right here. And then finally, anti-hacking. So there's the Computer Fraud and Abuse Act, which is the federal anti-hacking statute. Texas has a version of that. And it's just what it sounds like. it prohibits, you can't hack into somebody's computer system and take their information. So the obvious case would be an outsider somehow gaining access to your client's server and downloading or transferring data, right? Without any agreement, without any authorization. Clear case of hacking, that is unauthorized access. And that's the key concept, is unauthorized access. Pretty easy. On the other hand, let's take a case of an employee let's say an employee has access to the computer system. It's password protected, but they've got a password, they get on. The employee goes and pulls up some files that have nothing to do with that employee's job, right? And just said, oh, that looks interesting, saves that, then takes that with him when he leaves, okay? So it wasn't authorized, but on the other hand, the employee didn't really hack in, right? The employee had authorized access to that system. That's where it gets to be more of a gray area. In the Fifth Circuit, so covering Texas, the Fifth Circuit has said if an employee is accessing information and the employee knows that it's unauthorized, that can be a violation of the anti-hacking statute. But there's lots of scenarios that fall into this gray area. So that's the tricky part about the anti-hacking statutes. All right, so those are the basic legal duties that deal with employee treatment of confidential information. Any questions about any one of those? Or about anything else? Or comments? Yes, sir.
Spoliation.
Yeah.
My last deposition, they asked me if I knew what the elements were of spoliation.
That's an interesting question because, I think most lawyers would probably struggle to say what are the elements of spoliation. But let me I'll break it down real briefly. So first, there's got to be a duty to preserve, right? You don't have spoliation if there was no duty to preserve. When does duty to preserve arise? When litigation is reasonably anticipated. Now that's obviously a somewhat subjective standard, but the idea is if a reasonable person would have anticipated litigation in that situation, there was a duty to preserve. I'll give you a rule of thumb on that. At the point, if somebody's talking to outside counsel, there's probably reasonable anticipation litigation, right? Once somebody in the company is picking up the phone and calling outside counsel, it sounds like maybe they're anticipating litigation. If it's just in-house counsel, more iffy, maybe. Okay, so that duty is number one. And then number two is a breach of the duty. So a failure to preserve relevant evidence. Now, a failure to preserve something irrelevant is not going to be spoliation. And sometimes you've got a disagreement over whether the information was relevant or not. So failure to preserve, those are the two most basic elements. When you get beyond that, you're really talking about what's the remedy for it. And when you get into what's the remedy, that's when you get into what was the intent of the person who failed to preserve. And intent can be very important because intent is going to be what is the biggest factor in determining what the sanction might be. So you've probably heard about the sanction of giving an adverse instruction to the jury. So basically an instruction that says, party A failed to preserve evidence and you may infer that the evidence would have been unfavorable to party A. That's the adverse inference instruction, something like that, which no lawyer wants because, imagine having to be in the courtroom arguing against that. You start off at a disadvantage and it's going to be hard to recover. So duty, breach, intent would be the main elements. But, that question, what are the elements? Like I said, I think most lawyers would probably struggle to answer that one. Do you remember do you want to share what you said?
Well, I said I'm not familiar with the elements.
Yeah, I think that's a good answer. I think that's a fair answer. You said, I'm a forensic expert. You know, I'm familiar with the concept of spoliation, but I'm not a lawyer, and so it's not my job to say whether there was spoliation. My job is to say, you know, was information deleted or not? Is there evidence of this or that? I mean, you know, that's
In my report, I had said, hey, the cell phone had been reset an hour before it was turned in, and this could be potential spoliation.
yeah,
So
yeah.
he was hitting me back for using the word
Right,
spoliation.
right.
Well, I'm like, well, maybe I stepped too far, but
Yeah, yeah. No, I mean, it seems like that lawyers love to pick those things apart, right?
right.
I mean, what you said sounds fair to me, and I think the way you could answer the question is just to say, I don't know the legal definition, but my understanding of spoliation is deleting relevant evidence would be spoliation. I mean, it's just about as simple as that,
Sure.
right? Yeah.
So we work for companies, but we also work for couples like that are going through divorces
Sure.
and things like that. Years ago, it used to be like the laws around, you know, what is common law or common property, I guess is the legal term, but
Right.
basically, you know, a husband coming to us saying, I want you to investigate my wife's computer. They could have brought us the wife's computer without her knowing about it. We do all of our examination and we go from there. Have the laws, and we've been told that the laws have changed on that, so that, you know, his wife's computer actually is his wife's computer, not his computer. Do you know the laws around that? Can you kind of confirm that for us? Because we're still sort of, we play it safe.
Yeah.
I'm just wondering if that's for good reason, or if we're just being too conservative there, or what, so.
That's a great question. I don't do family law except sometimes pro bono, I'll do it.
Okay.
But so I don't know, but I would say this. I don't rely on the fact that something is community property as enough to say, okay, well then you've got a right, the husband has a right, or the wife has a right to that. You know, community property is really about, you know, who
Who gets the car?
who gets what when the judge enters the divorce decree.
Right.
Community property, that concept really wasn't designed for
Access
who-
to accounts.
who's allowed to access
Yeah.
this information.
Yeah.
That's a more difficult question.
Yeah.
So, I mean, I think you probably have to rely in large part on the lawyer you're working with
Yeah.
to tell you, and yeah, that could get real tricky.
Yeah, I mean,
Well, the lawyer you're working with, he wants you to go,
He's gonna say, go for
oh
it.
yeah, there's no problem. You're like,
Yeah.
just
Yeah.
make sure we have insurance before we
Back
go
off
for
here.
it.
Well, and so, and also you have to look at like terms of service, like for Gmail, for instance. Google's terms of service doesn't care about your marriage. If your name is on the email account, you're the legal person to be accessible or grant permission.
Yeah.
Your
yeah,
wife can't just say, go get his Gmail,
Yeah.
not according to the terms of service. You know?
Well, here's how I would look at it. If I was handling a divorce, the way I would look at it, if my client had lawful possession of the device when he or she gave it to me, I feel like that's enough, regardless of what may have happened before. Now, that doesn't mean, so I'm not gonna tell let's say two people are separated and one's got an apartment. So no, you can't go into their apartment, take their laptop, you know, something like that.
Yeah.
But if the client comes to me and the client already has the device, I would take the position at least, you know, it's not my job to determine, you know, did he or she legally, you know, take that. If it was in their home and they took it, I would feel pretty comfortable.
Yeah.
But yeah, that's a tricky issue though. I don't know, I don't have a great answer for you on that.
One of the things we do is in our engagement letter that they're required to sign before we start work is to confirm that they are the owner of the devices that they're producing to us, and so it provides us with a little bit of protection in those scenarios where it's not quite their device. So I just, like I said, most attorneys, again, this is one situation where most attorneys are on the up and up, but then every once in a while we have those that are either not familiar with the law or they're interpreting the law in the most literal sense, so that, you know, if it's in the family, it doesn't matter if it's who's got it, you know, it's in bounds, you know, so it's, little challenging for us though. with
Yeah.
justice and rest.
I can see that. I do know that the Texas Family Code has a sort of a gradation of community property. So you can have community property that is one spouse's, what they call sole management community property. So there's different classifications that might come into play. So maybe if a device is community property, but it's one spouse's sole management community property, yeah, maybe it might not be proper for the other spouse to take that and hand it over to a lawyer or an expert. So I think you're right to be cautious about it.
Okay.
So
Yeah.
just finish up real quick on just departing employees again, so.
Sure.
Where do you see the boundary? I guess it's just a goalpost that everybody pushes on company issued equipment, so a person departs, company issued equipment, they view it as their property. So as far as turning it over, but personal account, personal email, personal accounts, but it's been done, obviously on a work computer, it belongs to somebody else, it's not your computer.
Yeah.
Where's the privacy expectation or redaction goal line, or is that just literally under subjection, or do you see it more towards the employer because it's their property? They can just say, here, take it.
Yeah, another good question. I think usually if it's company property, then most likely the judge is going to look at that as fair game.
Okay.
You know, anything
So
on that
you
device.
find a personal email volume, something like that, too bad, it's, you shouldn't have done it on your work computer.
Yeah, now the tricky part, I mean, what do you do with that? That doesn't mean a company, can do anything it wants with that information. If you find,
Of course, they're gonna say, index it, search it, we wanna know if there's any of our documents attached.
Right,
So next
right.
thing you know, we're in, obviously, territory of a personal email account, which probably was never agreed upon, but they're like, well, did they email anything to it?
right,
They
right.
wanna know if their documents are in there.
Yeah, I think if your mission is legitimately focused on company information and not like just trying to embarrass somebody or do something improper, then a judge is unlikely to have a problem with that.
So the next word, I tend to wanna just filter out document attachments, do the listing route and go, here, let's take a look at these listings of attached documents in the personal email. Do you see anything that you would wanna claim or and then we can produce from that, obviously, that way respect privacy at the same time and give them a chance to see some insight into it, but obviously, without having to reveal it all.
I think that's a reasonable approach. Yeah. Well, great questions.
You may have questions.
Steve?
I got one more for you, just with this audience, because I know you have spoken about this.
Yeah.
The upcoming changes to the Texas rules in regards to communication with expert witnesses, which then applies a lot to
Yeah,
what
yeah.
we do. So if you could just inform everybody that doesn't know about. what
Yeah,
we've
okay,
done.
sure. So the issue is, are expert communications with the hiring counsel privileged? Or are they discoverable? And right now in Texas, the general rule is that they are discoverable. And you've probably encountered that. And that means, you have to be real careful about how you communicate with lawyers, and lawyers are probably a little uptight about that, at least if they're thinking about it, right? Now, the federal rules changed, and I forgot exactly what year it was. The federal rules changed to where generally the lawyer's communications with the expert now are not discoverable. And the rationale for that was basically, we don't want people to have to do all this crazy jumping through hoops to make sure there's nothing in writing with the expert. It increases the cost, it's less efficient. The idea was, let's just let attorneys and experts communicate freely and not have to worry about those communications being discoverable. And of course, there were other people who said, no, but then you're gonna have experts and attorneys, they're gonna be doing things improper. What's that?
Playing hide the ball.
Yeah, playing hide the ball and stuff like that. But on balance, the thought was it'd be better to just make it easy. And yeah, there's a proposal to change the Texas rules so that they would be like the federal rules, and those communications would generally not be discoverable. And that has been, the last time I looked at it, it had been recommended by the Discovery Subcommittee of what they call the Supreme Court Advisory Committee. And I don't know where it is at right now at the moment, but I would expect that's on the way. If that does get changed, it probably makes your lives easier.
Yes, it does.
I think it's probably a positive, and makes lawyers' jobs easier. Now, one thing people can do, and here's another thing you can suggest when you're working with a lawyer. Suggest that the opposing sides agree that the expert communications will not be discoverable. The sides are free to stipulate and agree to that if they want, even without a rule change. And a lot of times, the other side will say, well, yeah, let's agree to that because we don't want you looking at our communications with our experts. So that's something maybe when you're first engaged, you suggest, you might want to agree to this. And then if you don't, then that's good to know because then you may need to adjust how you communicate with the lawyers. I'll tell you where it gets difficult is with expert reports. And y'all have probably encountered this. As a lawyer, I don't want my expert just to send me a report and that's it. And now I'm stuck with this report and I'm like, wait a minute, there's something here you failed to deal with or, there's a mistake here. Like I want to see the draft of the report. On the other hand, I don't necessarily want this long paper trail of me that looks like me telling the expert what to say in the report. I don't want that either. And so lawyers go through all kinds of gymnastics trying to deal with that. Sometimes lawyers will even just sit down in an office with the expert and they'll bang out the report together so there's no email trail of what were the changes to the report.
WebEx.
Yeah. So anyway, I think it's probably going to be a good change, make our lives easier, but we will wait and see if it actually happens.
Cool.
All right. Well, thanks again, y'all. Great questions.
Awesome, thanks, Zach.
Yeah, you're welcome.